Most people use the words rights and freedoms as synonyms in everyday conversation, treating them as two different names for the same thing. Inside a Canadian courtroom, however, blending these terms is legally incorrect. Under the 1982 Charter, a right and a freedom operate as distinct mechanisms with different requirements. The difference between them is defined by the specific relationship between the individual and the government. It comes down to one question. Does the protection require the government to step in and build a system, or does it require them to step back and leave you alone? This active-passive binary determines exactly how and when you can hold the state accountable under the law. A freedom is defined as the ability to act, speak, or believe without interference. Under Section 2, freedoms like religion and expression are natural states. The state must step back, creating a vacuum where you act without friction. The government doesn't fund programs for freedom of thought. They just stay out of your way. Because these protections are passive, they apply to every person physically present in Canada, including tourists and visitors. They are universal boundaries. Ultimately, a freedom is a constitutionally protected line that the state is not permitted to cross. A right is different. It is a specific power actively granted to citizens by the law. These are not natural states. Humans are not born with an innate ability to hold a federal election or attend a French-speaking school. These are artificial structures that must be designed and funded. This includes democratic rights like the ability to vote, mobility rights, and official language rights. These specifically require the government to step in and actively provide the infrastructure to make the protection real. This same active framework applies to collective rights. The 1982 Constitution Act provided formal legal recognition for Indigenous peoples, Inuit, Métis, and First Nations, allowing them to negotiate for specific land claims and cultural protections that the state must uphold. Unlike a freedom, a right does not exist automatically. It is a legal promise that the government must actively build and maintain. Despite these protections, neither a right nor a freedom is absolute. Section 1 of the Canadian Charter officially contains the Reasonable Limits Clause. This clause allows the government to restrict these protections if the restriction is necessary to keep society safe. This is the distinction between a measured democracy and an authoritarian state. In North Korea, the government exercises total control over expression and media, meaning freedoms are completely suppressed rather than reasonably limited. In Canada, the limits are specific. You have freedom of expression, but not for hate speech. You have freedom of assembly, but your protest cannot be violent or block emergency services. The Charter is a tool for calibration, balancing individual power against the safety and rights of the wider community. The distinction between rights and freedoms ensures that the legal system balances individual autonomy with the obligations of the state. This creates a dual-purpose system. The Charter acts as a shield against government overreach through freedoms and as a builder of equitable public systems through rights. These two mechanisms must work in tandem to keep the law consistent and fair for everyone. However, these protections are also tied to civic responsibility. The Charter establishes that for every protected right, there is a corresponding duty, such as the responsibility to respect the rights and freedoms of others while exercising your own. Because the law provides you with these active rights and passive freedoms, the final requirement of the system is that you protect and defend those same standards for the rest of your community.